Here are just a few money myths that you might have heard from different sources, and hopefully I'm going to clear some of those up today. So if you've been having disagreements and arguments and debates about these with your friends, maybe down the pub or online or within your family, then some of these you can now win over this Christmas period when you're sat around the table arguing and debating about them, because I'm going to clear some of them up for you. So welcome back. I'm the Black Belt Barrister, helping you to understand law, and in this video clearing up some misunderstandings about money and contracts and exchanges and agreements. So first of all, one of the things that I've heard multiple times is from somebody that there was no contract, therefore that they cannot sue, they cannot demand the money, and all of these kind of things. What they usually mean is that there is no written contract or no signed contract, meaning that it hasn't been reduced to writing, all of the terms haven't been put down on paper, and much less signed between the parties. That doesn't mean, however, that one party cannot sue the other party for the money. Because if there is an agreement to form legal relations, what we call a meeting of minds in the legal sense, in other words, two people have come together, they've agreed between them, one person is going to do something or sell something or provide something, the other person is going to pay for it or give something in exchange for it, or just pay some kind of money for it over a period of time, whatever it might be. If there is an agreement between those two parties, then there is a form of contract because there's been a meeting of minds, the intent to form legal relations, and so long as it meets the minimum requirements for a contract, which I'll come to in a moment, then you can enforce payment from the other person if they fail to pay. So what do we mean by the minimum terms of a contract? Well, there's got to be at the very, very least three things. There's got to be an offer of some kind. So offering goods or offering services or offering for sale, something along those lines. There's got to be some kind of offer from one person to another or one company to another. Secondly, there's got to be acceptance of that offer. So once the person has been given the offer, they must in some way indicate that they've accepted that offer. In a shop, this would be you taking the product to the counter. You are offering the money for that product. So once there's acceptance of that offer to purchase something or to pay for something, the third requirement is there's got to be consideration. So everybody gets something. One person might get a service, one person might get the product or whatever it might be, and the other person is getting the money in exchange for that. Providing you've got all three of those, then there is a valid contract between the parties, and you can, if they fail to pay, sue for the payment of that service or goods and so on. Now, there are certain requirements for these contracts. Terms have got to be fair, they've got to be legal, they've got to be sufficiently and reasonably certain. It cannot just say, I will give you this thing at some point in the future. Not sure when yet, but I will give it to you so long as you pay me money. If it's very uncertain in terms of time and space and value and things like that, then it's quite likely to be an invalid contract because it's not certain enough. However, if, let's take an example of inviting someone to mow your lawn and do your garden work, and you've agreed the time and you've agreed what they need to do, the only thing you haven't agreed is how much they're going to charge you for it. Now, just because they haven't agreed the precise amount of money that they are going to charge for this, again, doesn't necessarily preclude them from claiming against you if you fail to pay. If they were to come and do the work, they've done everything that you've agreed that they would do, and you haven't agreed how much money yet, but then you fail to pay or refuse to pay because you haven't agreed how much money, they could still take you to court, and ultimately, if you don't dispute that they did the work and you asked them to do the work and that you were going to pay for it, then the court will decide on what's known as a quantum meruit basis, which is an assessment of value or consideration, a reasonable value for the services that they've provided. And then if the court finds in their favour that you do owe them some money, this is how the court will determine how much money is owed. What the court might do in that situation, and this is a real life example, this is how it does happen in court, the court might say to you, if you are on the paying side and you fail to pay, what do you think the work is worth? They'll ask you to write it down on a piece of paper and hold it up all at the same time. They'll do the same to the other person or the other company, write down what you think the value is of the work, and then they will hold it up at the same time. The judge will probably also write down what they think the value of the work is. This might be based on an hourly rate, it might be based on a one-off price for the project, having heard views of both parties. And then the court is going to make a determination, if it can't be agreed between the parties, as to what that value of work should be. All of which after deciding that in fact you do have to pay them because they've done the work. So this is the very first thing that a lot of people get confused by, is that just because you don't have a fully drawn up written contract, it doesn't mean the contract doesn't exist, and it doesn't mean you can't be sued for failure to pay under that contract. The next thing is how names are written and whether they are signed and things like this. Some people have been led to believe that if the name is all in all capitals, then it means something slightly different and then doesn't apply to the person and can't be enforced against the person. This is absolutely not true. It doesn't matter a jot whether the name is in capitals or even whether it's spelt incorrectly or not, so long as there isn't a mistake as to who the party was supposed to be. If you spelt the name John with or without an H and you chose the wrong one in the contract, this is going to make absolutely no difference whatsoever as to the person involved in the contract and whether they are liable under the contract. Equally, even if a contract is not signed, whilst it's better, of course, if it's signed and agreed, particularly when there's a dispute over terms, but if that contract is there and it's shown that you had a copy of this contract before you made the payment against it, and then the product was delivered or the service was delivered, and then there's some kind of claim going into court about it, you cannot then say, well, the contract is entirely void because you didn't sign it. That isn't how it works, and a court is not going to accept that at a starting position. The court will, however, in some situations consider whether a contract was void from the beginning. Voidable, meaning that if there's some kind of term which, if breached, gives you the option to void the contract and, in other words, relieve the parties of obligations and various other things, and whether the terms of the contract were fair and therefore whether those terms were enforceable, whether the terms were reasonable, and whether there was a breach of any of the terms, such as the time frame, maybe for delivery, maybe for the duration of provision of services, and all of these kind of things. The court is still going to look at those terms in the contract, whether you've signed this contract or not. Speaking of contracts being written down and signed, the reverse might be true as well. Some people believe that if a contract is written down and signed, then it's absolutely enforceable, it's completely legal, and there's nothing you can do about it. But that's not the case either. So on one hand, a contract need not be written down and signed to be enforceable and in existence, but the reverse is true as well. This is usually the case if there's a really unfair term or notice within a contract that simply couldn't be binding on a consumer, for example. Then regardless it's written down and signed, it's not going to be enforceable. So if there is a term within a consumer contract, with some exceptions, but if there's a term in the consumer contract that says no refunds under any circumstances, that is almost certainly not going to be enforceable because the Consumer Rights Act makes that an unfair term. And there's a whole list of these in the schedules to the Consumer Rights Act. So if you're interested in those, drop some comments below and I'll come back to some of those unfair terms in another video. The next thing is if a certain person is not named in the contract, and maybe there's only one person named in the contract, that some people have been led to believe that that person cannot enforce the contract in any way at all because they're not named in the contract. And again, that's not strictly true, because there is legislation that provides for the rights of third parties. And this is legislation which, as it sounds, provides rights to enforce a contract in certain situations by a third party if they receive some kind of benefit or the contract bestows some kind of benefit on that person, either expressly, as in it's written within the contract that they have this benefit, or as a matter of construction, which might be that they receive this benefit because it's a family car or a family home or something like that, and they are going to benefit, let's say, from the services or the provision of products or whatever it might be under the contract. If it's a married couple but the contract is only in one person's name, then quite obviously the other person is going to benefit under the contract, and they are in many situations going to be able to enforce the rights under that contract, irrespective of whether they are named in the contract or not. Look out for terms which expressly exclude rights of third parties within the contract. If you find one of those, I'd be suggesting you take legal advice and perhaps request that that one's taken out if you want to ensure that the third party retains their rights to enforce under the contract. Now, speaking of terms in the contract, some people believe that you need to have legalese and legal terminology that is absolutely specific to mean the right thing, and otherwise it doesn't work within the contract. And that's not true either. The terms must be clear, that's for sure, but the terms don't have to be proper legal terminology or refer to acts of law and these kind of things. They can simply state in plain English, we are going to do this and you are going to pay this amount of money. We'll do it by this date and you will pay by this date. So long as those terms are clear and fair and legal, of course, then they will be enforceable. Another common misconception is that if something is buried within the small print, well, it's tough. You just have to be bound by it in any event. Now, this comes with a caveat because there are certain things which are fairly standard which are in the small print, so it will sound somewhat contradictory. But if there's a particularly onerous term within those small print buried deep in the contract, then a court might well find that the company didn't bring it to your attention in the case of a consumer, and therefore it'd be unfair for you to be bound by it. Because with a particularly onerous term, it should be brought to your attention much more prominently than buried in the small print. So those are just a few of the things that I can think of that people have been confused about. I hope you found this overview useful. Please give it a thumbs up if you like this kind of content. Share it with someone that you think would find it interesting. And as always, thank you for watching.